Maryland has a well-developed lease termination framework that combines state law with strong local regulations, particularly in the Baltimore metro area and the D.C. suburbs. The governing law is found in Maryland Code, Real Property Title 8, along with the state's summary ejectment procedures. If you manage rental property in Maryland, the process is detailed and the courts expect strict compliance. Let's start with no-cause termination. For month-to-month tenancies, Maryland requires either party to provide at least 1 month's written notice before the termination date. The notice must expire at the end of a rental period. So if rent is due on the 1st and you want the tenancy to end on the last day of March, you need to deliver notice before March 1st. However, and this is critically important, some Maryland jurisdictions have enacted just cause eviction protections that restrict a landlord's ability to terminate without cause. Montgomery County and Baltimore City have both been active in tenant protection legislation, and landlords in these jurisdictions need to verify whether local just cause requirements apply before serving a no-cause termination notice. The rules can change quickly in Maryland's politically active jurisdictions, so staying current on local ordinances is essential. For fixed-term leases, the lease expires at the end of the agreed term. Maryland does not require additional notice at the natural expiration unless the lease specifies otherwise. If the tenant remains after the term and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 1-month notice requirement. For week-to-week tenancies, 1 week's notice is required from either party. Now let's cover termination for cause. For non-payment of rent, Maryland has a process that's faster than many states, but includes important tenant protections that have been strengthened in recent years. Maryland allows the landlord to file for eviction once rent is overdue. Under the state's summary ejectment statute, the landlord does not need to provide a separate pre-filing notice demanding payment. The filing of the complaint itself serves as the notice. This means that technically, a Maryland landlord can file for eviction the day after rent is due. In practice, most landlords wait until rent is at least a few days or a week late before filing, but there's no statutory waiting period. The tenant then receives a summons and has the right to appear in court. At the hearing, the tenant can pay the full amount owed, including rent, late fees, and court costs, and the case will be dismissed. This right of redemption is a critical protection for Maryland tenants and can be exercised at or before the court date. Here's where Maryland has gotten more tenant protective in recent years. The state passed legislation requiring landlords to provide tenants with a notice of the right to redeem and information about available rental assistance programs. This notice must be provided before or with the filing of the eviction complaint. Failure to provide this notice can affect the landlord's ability to proceed with the eviction. Maryland also has a specific provision regarding the timing of late fees and eviction filings. Landlords cannot charge a late fee until rent is more than 10 days overdue for properties in Baltimore City, and similar local restrictions may apply in other jurisdictions. The interplay between late fees, grace periods, and the eviction filing timeline is something Maryland landlords need to understand clearly. For lease violations other than non-payment, the process depends on the nature of the violation and the terms of the lease. Maryland's Real Property Code Section 8-402.1 provides that a landlord may bring an action for repossession when the tenant breaches the lease. The landlord must provide notice of the breach and, for most curable violations, give the tenant a reasonable opportunity to correct the problem. For violations that involve a clear and imminent danger, such as criminal activity, drug offenses, or conduct that threatens the safety of other residents, Maryland allows the landlord to pursue eviction on a shortened timeline. The landlord can file for repossession without providing an extended cure period when the circumstances involve serious health or safety threats. Maryland has a specific provision addressing drug-related activity. Under Real Property Section 8-402.1, if a tenant or someone under the tenant's control is involved in drug-related criminal activity on the premises, The landlord can terminate the lease and pursue eviction. The landlord doesn't need to wait for a criminal conviction. Documentation of the drug activity is sufficient to support the filing. One thing that makes Maryland's framework complex is the significant variation between jurisdictions. Baltimore City has its own rent court, formerly known as the District Court Rent Docket, that handles residential eviction cases exclusively. Baltimore's rent court processes an enormous volume of cases and has its own specific procedures and local rules that differ from courts in other parts of the state. Landlords in Baltimore must be familiar with the rent court's particular requirements. Montgomery County has enacted extensive tenant protections, including a right to counsel program that provides free legal representation to tenants facing eviction. Prince George's County has implemented similar protections. In these jurisdictions, landlords should expect that tenants will be represented by attorneys and that the eviction process will be more contested and potentially longer than in jurisdictions without right to counsel programs. The broader eviction process in Maryland goes through the district court. The landlord files a complaint for summary ejectment, and the court schedules a hearing, typically within 1 to 4 weeks depending on the jurisdiction. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a period to appeal, 4 days for failure to pay rent cases in Baltimore City, and varying periods in other jurisdictions and for other grounds. If no appeal is filed, the landlord can request a warrant of restitution. The sheriff then carries out the physical eviction. The overall timeline from filing to removal varies significantly by jurisdiction. In some Maryland counties, the process can be completed in 3 to 5 weeks for uncontested cases. In Baltimore City and the D.C. suburbs, the timeline can be longer due to higher case volumes and additional procedural requirements. Maryland also has specific provisions regarding the stay of eviction during the winter months and during declared emergencies. Courts have discretion to delay evictions when extreme weather or emergency conditions make physical removal dangerous or impractical. During the COVID pandemic, Maryland implemented extensive eviction moratoriums, and while those have expired, the framework for emergency stays remains in place. On the tenant side, Maryland provides several grounds for early termination. If the landlord fails to maintain the property, as we covered in our Maryland habitability video, the tenant can file for rent escrow under Section 8-211, which can ultimately lead to lease termination if the landlord doesn't address the deficiencies. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Maryland has a significant military presence, including Fort Meade, the Naval Academy in Annapolis, Andrews Air Force Base, and the Aberdeen Proving Ground, making this provision relevant to a large number of tenants. Maryland provides early termination rights for victims of domestic violence, sexual assault, and stalking. Under Real Property Section 8-5A-02, a tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid protective order, a police report filed within the preceding 60 days, or a written statement from a qualified professional. The tenant must provide at least 30 days' notice before the termination date. The landlord cannot charge early termination fees, cannot report the early termination as a lease violation, and must return the security deposit in accordance with normal procedures. Maryland's domestic violence termination provision also includes important protections against landlord retaliation. The landlord cannot refuse to rent to a prospective tenant based on the fact that they previously terminated a lease due to domestic violence. And the landlord cannot include the domestic violence termination in any tenant reference they provide to future landlords. Maryland also provides early termination for tenants who are called to active military duty under the state's own military protections, which complement the federal SCRA. Maryland strictly prohibits self-help evictions. Under Real Property Section 8-216, a landlord who attempts to regain possession of a dwelling unit by force, threat, or by shutting off utilities is liable for actual damages and may be subject to a civil penalty. Tenants who are illegally locked out can seek emergency court relief to be restored to possession. Maryland courts take illegal lockouts seriously, and landlords who engage in self-help face both immediate penalties and long-term credibility damage. Maryland's anti-retaliation protections are found in Real Property Section 8-208.1. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant exercising their legal rights, including filing a rent escrow action, reporting code violations, or participating in a tenant's organization. The statute creates a presumption of retaliation if adverse action is taken within a specified period after the tenant's protected activity. One important practical consideration for Maryland landlords. The state has specific lead paint requirements that can directly affect the termination process. Under the Maryland Lead Risk Reduction in Housing Act, landlords of pre-1978 properties must comply with lead paint registration, risk reduction, and certification requirements. If a tenant reports a lead paint concern, the landlord must address it, and filing for eviction after a lead paint complaint can trigger both retaliation claims and lead paint enforcement actions. Maryland requires landlords to return the security deposit within 45 days of the tenant vacating the property. The landlord must provide an itemized list of any deductions. If the landlord fails to return the deposit within 45 days, they may forfeit the right to retain any portion and could be liable for up to 3 times the amount wrongfully withheld, plus attorney's fees. Maryland also limits the security deposit to 2 months' rent and requires the deposit to be held in a separate escrow account at a Maryland financial institution. For the complete guide to Maryland lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.